On the agenda today, a lot to cover, so welcome. Welcome our guests who are here also to bring comment and presentations. But what I'd like to do is call the meeting to order. Our Charter Review Commission meeting is called to order for Wednesday, March 23rd, 3 p.m. I would like to call for a motion for the adoption of the meeting minutes from March 2nd, 2022. Do I have a motion?
So move.
Do I have a second?
Second.
All in favor?
Aye.
Opposed? Okay, meeting minutes pass. Old business. We want to have a brief discussion today, particularly around the consideration of the auditor's charter amendments. I believe that everyone received the portal information in order to retrieve the documents for this meeting today. And within that, there was the recommendations from the auditor. I do believe she's not able to be here today. But we would like to really, as we had talked about as far as our process moving forward, to have the presentation, have discussion, have time to review the information, have the information be presented again, and hopefully make a decision moving forward whether we will send those recommendations forward. So, John?
Sure. So there was a motion drafted for this to accept the recommendations of the city auditor with revisions by the city attorney's office. And Laura is here to answer any questions you may have on some of the language. I placed the recommended changes in the document that you received in the motion. The motion was to accept the recommendations of the city auditor with revisions by the city attorney's office to consider in the Charter Review Commission's final recommendations to City Council the potential amendment of sections 26, 84, 91, 93, 120, and 226 of the city charter. Going through section 26 concerning the edits to the mayor's estimate. Section 84, payment of claims. Section 91, disbursement of funds. 93, depositories and investments. 120, outstanding utility debt obligations. And 226, oath of office. A large portion of these were modernizing the language and doing general housekeeping updates to make sure we were in line with the Ohio Revised Code. For example, the final couple being, and then the oath of office, 226, being changing the repository for where we keep those oaths of office, for example, from the auditor to the city clerk, where it seems to be a good deal more appropriate as they also keep a copy anyway. And in the ORC, that's generally the repository for those things. So those are the recommended changes for consideration today. In taking this motion, it's a consideration to include them in the final recommendations.
Okay, after that brief overview, do we have any comments by any of the commission members? Carrie?
I'll just say I really appreciate John and the staff for putting this concise summary together and allowing us the time to hear the recommendations, process it in the second meeting, and then come back and see this in sort of clear language and vote on it. So that was my only comment, Chair. Just appreciate the document that was put together today, and that's before us right now.
Wonderful, thank you. Any other comments by other commission members? Okay, hearing none. Do we have a motion to to recommend the city auditor's recommended changes for the charter forward?
So move.
Second.
All in favor?
Aye.
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 Opposed? Any abstentions? Okay. The city auditor's recommendations are moving forward. Thank you. New business. We're going to be discussing with our guests that are here today that being former Rep. Mike Curtin, Director Joe Lombardi, Director of Finance for the City of Columbus. I know the auditor was not able to be here today, as well as always, Laura Baker Morish from the City Attorney's Office. So let's go ahead and get started with the presentations of self-dealing and resident tax revenue protections.
Thank you,
Rep.
Chair
Burton.
Bartley. Is this volume level good, bad, acceptable?
Can everyone hear?
Yes.
Thank you. Chair Bartley and members of the Columbus Charter Review Commission, thank you for serving on this important panel, and thank you for allowing me the opportunity to share some historical perspective on the initiative process in Ohio and in Columbus, and on the current need for reform. I had the privilege of serving on the city's Charter Review Commission of 2014, which, among other reforms, recommended establishing decennial review commissions following each federal census beginning this year. So I am pleased to play a role in the inauguration of this process since we recommended it back in 2014. This requirement reflects the Jeffersonian ideal that to properly serve the people, our foundation documents, our constitutions and charters cannot stay fixed under glass, but need to adapt to changing times and circumstances, and be re-examined at regular intervals to give citizens an opportunity to voice concerns over and consider changes in the structure and workings of their governments. As a newspaperman for 38 years at the Columbus Dispatch, a state representative for 4 years, and a member of the Ohio Constitutional Modernization Commission during my tenure in the General Assembly, I've long tried to study and report on the evolution of our state and city governments. This discussion is devoted to the use and abuse of the power of the initiative. Ohio has long been a leader among the states in providing its citizens with the power of the initiative. Since 1912, Ohioans have been empowered to initiate laws and state constitutional amendments by gathering signatures on petitions to place issues on the statewide ballot. And since 1914, the Columbus City Charter has granted similar powers. By petition, Columbus voters can place issues on the city ballot to initiate charter amendments or city ordinances. For the most part, the power of the initiative has served Ohio and its cities very well. Its mere presence in the Ohio Constitution and in hundreds of our state's city charters reminds lawmakers of where ultimate authority resides, and that was the original purpose of the initiative. It is instructive for citizens and office holders to understand the original purpose of the initiative, born in the turn of the century progressive era, generally defined as the period spanning the 1890s to the 1920s. The progressive era spawned many reforms in response to the rampant corruption that existed in city, state, and national politics. The reforms took aim at monopoly barons, price fixing, and elected officials on the take, to name just a few of the ills of the day. At the dawn of the progressive era, Ohio was as corrupt as any state you would find. Its biggest cities were run by political machines and their bosses, known for vote buying and selling and a variety of other corrupt practices. Our riverfront out here, which we take so much pride in now, was a sea of houses of ill repute and gambling houses and all sorts of places that stayed in business because our police department was on the take. We had as corrupt a police department as any in the country. Not the history we brag about in our city. George S. Marshall, reflecting those concerns, the 35th mayor of Columbus from 1910 to 1911, wrote, "The brewers and other liquor interests and the public service corporations, the utilities, dominated the life of the city, and the spoils system ruled most everywhere." It was in this environment that Ohio held its fourth state constitutional convention at the State House in 1912. And no, I wasn't there, but I've studied it quite a bit. And that convention produced 42 proposed amendments to the Ohio Constitution. Speaking of a bedsheet ballot, our voters in Ohio entertained 42 proposed amendments to our state constitution and approved 34 of them. Among the reforms were the constitutional initiative, the statutory initiative, and the referendum. The last time I checked, Ohio was one of only 18 states that offered its citizens all of those. When Teddy Roosevelt, the great monopoly buster, came to the Ohio State House on February 21st, 1912, to address that state constitutional convention, he promoted the initiative, strongly promoted the initiative for its potential to check the monopolists and all those whose prime interest was and is special privilege. This was the same constitutional convention that produced Ohio's Home Rule Amendment, allowing Ohio cities for the first time to craft their own charters and escape micromanagement by the state legislature. Columbus quickly took advantage of this new power of self-government. The city created your predecessors, its first charter commission, to draft a city charter for voter consideration. The commission was co-chaired by the noted reformer Washington Gladden, pastor of First Congregational Church, who was a contemporary and a friend of Teddy Roosevelt, and William Oxley Thompson, president of the Ohio State University. That first charter, approved by Columbus voters on May 5, 1914, provided citizens with the power of the initiative and referendum modeled after our state constitutional provisions. A substantive difference between Ohio's constitutional initiative and the Columbus City Charter initiative was that the state constitutional initiative set a 10% signature requirement, 10% of Ohio electors, which remains in law, remains in our Constitution, while the Columbus City Charter set a 6% requirement, or 6% of city electors. 21 years later, in November 1933, Columbus voters approved a charter amendment lowering that required signature threshold to 5%, which remains in place today. For approximately 7 decades, the initiative process in Ohio and other states worked for the most part as intended, as a check on monopolists, as a check on special interests, and a direct democracy tool for citizens to advance societal goals being ignored by lawmakers. In Ohio, that meant everything from women's suffrage to the minimum wage. But a troubling trend began to emerge in the 1980s and 1990s and has gained momentum since. Some sharp political operators, beginning on the West Coast, California, Oregon, Washington primarily, developed the idea that the initiative could be used to obtain special privilege, even monopolistic privilege, for a given set of investors. If the cause were popular enough or popular sounding enough, investors could be recruited to finance an initiative campaign to allow them to corner the market on a sector of the economy in a state or municipality. In 2000, Pulitzer Prize-winning journalist David Broder of the Washington Post, for decades the dean of American political journalism, the most respected of American political journalists, published a book titled Democracy Derailed: Initiative Campaigns and the Power of Money. That book chronicled the emergence of this new industry dedicated to securing private and exclusive economic benefits via the ballot initiative. The original purpose of the initiative was in the process of being turned on its head. 2 years after publication of Broder's book, the National Conference of State Legislatures convened a special task force to examine the abuse of the initiative, and I would recommend that report to you for further research. That task force examined data from across the nation and concluded, quote, "The initiative has evolved from its early days as a grassroots tool to enhance representative democracy into a tool that too often is exploited by the special interests," close quote. These special interests span the ideological spectrum from far right to far left. In various states, they have sought to corner the market on everything from green energy to highways, from education funding to marijuana. Bipartisan concern over such abuses prompted a committee of the Ohio Constitutional Modernization Commission in the summer of 2013 to begin discussing potential reforms to our state's initiative process. I was privileged to serve on that commission and in that committee. Committee members were mindful of Ohio's experience with casino operators who in 2009 successfully used the initiative process to not only establish 4 casinos in 4 cities owned by 2 companies, but also guaranteeing and limiting what their tax rates would be. Committee members also were aware that a group of investors was planning a statewide initiative to corner the market on the commercial sale of marijuana, an amendment that appeared on our Ohio statewide ballot in November 2015. Had that amendment been successful, it would have declared that only 10 pieces of property in the entire state, only 10 pieces of property, owned, of course, by the backers of the initiative, could be used for the commercial cultivation of marijuana. These experiences led me to co-sponsor an amendment to the Ohio Constitution placed on the November ballot of 2015, along with the Marijuana Monopoly Amendment, by a bipartisan vote of the Ohio General Assembly. For me and most of my colleagues in the legislature, the issue wasn't marijuana. The issue was a set of investors attempting to put their business plan in our state constitution. We wanted to protect Ohio's initiative process from being used for personal economic benefit and, yes, monopolistic benefit. Fortunately, Ohio voters approved that amendment, so now the Ohio Constitution has a very high barrier to prevent self-dealing entrepreneurs from being able to insert their monopolistic business plans into our state's foundation document. This, and I apologize for the detail, but this is the background that brings us to a self-dealing entity known as Pro Energy Ohio LLC. For many years, beginning in 2012, Pro Energy LLC attempted to qualify a proposed constitutional amendment for Ohio's statewide ballot. That first attempt sought to transfer, it's not a typo, $13 billion in state bond money to a New York account controlled by an unknown group of investors. This investor group, if successful, supposedly would have taken it upon themselves to pursue green energy initiatives to benefit Ohio. This proposed statewide measure died when the petition group failed to secure the required 385,000 plus signatures. Subsequently, the group failed several more times to qualify for the statewide ballot. After Ohio voters approved the 2015 anti-monopoly amendment prohibiting use of the constitutional initiative to create, and this is now part of our Constitution, to create a commercial interest, commercial right, or exclusive economic benefit not available to similarly situated persons or non-public entities, Pro Energy LLC recognized this high barrier and turned its attention then away from a statewide initiative and toward us, toward a Columbus initiative. After failing in 2017 to secure the required number of signatures, the group reappeared in 2019 with an initiative whose aim was to secure, as Joe Lombardi knows better than anyone, $87 million in city general fund revenues. After a legal battle over the sufficiency of that petition, it was cleared by the Ohio Supreme Court for the November 2021 ballot, where it appeared as Issue 7. Had that initiative been successful, the city auditor would have been required to transfer $87 million in general revenue funds to an account controlled by Pro Energy Ohio LLC, purportedly for management of renewable energy initiatives. Fortunately, Columbus political and civic leaders organized a very effective campaign to educate voters on the self-dealing nature of Issue 7, and it was overwhelmingly defeated in last November's election, November of 21. However, as most of you know, Pro Energy Ohio LLC is back. 3 weeks ago, on March 4, it filed a statement with the city clerk of its intent to circulate another initiative petition, this one seeking to claim $42 million in city general fund revenues, purportedly, of course, for management of renewable energy initiatives. The prime mover behind Pro Energy Ohio LLC, John A. Clark Jr., has been indicted on 4 felony charges related to election falsification and tampering with government records, all related to Issue 7. As we sit here, Clark awaits trial in Franklin County Common Pleas Court, And as we sit here, we don't really know who his financial backers were or are. That's why he's facing those 4 felony charges. When County Prosecutor Ron O'Brien took a look at that case, he said these are fraudulent. What Clark did was list names and addresses of the people claiming they gave money, but they weren't the people who gave the real money. So hopefully that trial, when it comes, will begin to reveal, to peel the layer of the onion back, and we can find out who the real backers are behind Issue 7 and its successor. Unlike the Ohio Constitution, the Columbus City Charter has no safeguards against self-dealing abuses of the initiative process. The City Charter has no subject matter limitations on the use of the initiative process. As someone who hit the campaign trail last fall to address some of our area commissions and civic associations about the dangers of Issue 7, I can attest that neighborhood leaders were greatly surprised to learn that our city's initiative process is vulnerable to this type and this magnitude of self-dealing abuse. I can also assure you that legislators and legislative leaders in the Ohio General Assembly have taken interest in studying how they might assist Ohio's municipalities in safeguarding the initiative process from such abuse at the local level. Ohio has 213 cities and approximately 600 villages whose electors, like those of Columbus, enjoy the right of the initiative. Which potential safeguards you may choose to recommend and which safeguards the Columbus electorate may choose to approve this November will be studied very carefully at the State House as potential model legislation for other Ohio municipalities. The leadership of the Ohio Senate is aware of your deliberations on this issue. I've been in contact with State Senator Herschel Craig of Columbus, as you know, a former Columbus City Council member, and State Senator Stephanie Coonsey of Hilliard. They both have expressed interest in potentially bipartisan co-sponsorship of reform legislation to assist all of Ohio's cities and villages and await our city's experience to help guide their further deliberations. Chair Bartley and Commission members, I hope this historical summary is of some value in your deliberations. I'd be happy to entertain any questions either now or at the end of all the presentations, however your agenda may see fit. Thank you very much.
Mr. Curtin, I want to thank you for this very robust history. I love detail, and this gave me clarity to understand exactly why we are where we are and how we're to move forward, understanding what the intent was, understanding what the abuses have been and are currently continuing, and how we as a city or as a commission can really change that trajectory so that there is equity and within the decisions that are made regarding funding that comes into the city of Columbus, that should be rightfully used in a very beneficial way for the residents. So thank you for this. Very appreciative of it. As I said, it gives me an understanding, and I'm hoping and I'm believing the rest of the individuals who are around this square or rectangle as well. So thank you.
Thank you.
Any other comments, questions from committee members?
I do have a question. I try to hold on. But thank you for your testimony. Representative Curtin, since 2005, and this is kind of asking the measure of success since 2015, since the passage of the amendment prohibiting the use of constitutional initiatives, how successful has that amendment been?
Chair Bartley and Member Bryant. One would have to deduce it's been successful so far in that we've not seen an organization, a petitioning organization, come forward and attempt to use the state's initiative process for a proposed amendment or proposed law that would violate the provisions of the Ohio Constitution that were adopted in 2015. So I would say so far, so good.
Thank you. Thank you.
Any other
I have a
questions,
quick
comments?
one.
Go ahead.
Thanks, Chair Bartley. Can you talk, thank you, by the way, for the presentation, the historical context, very helpful for our discussion here. I was wondering if you could share with the commission a bit more about some of those barriers that have been placed in the Ohio Constitution from that constitutional amendment that was passed in 2015. Can you just talk a little bit more about those?
About the barriers?
Yes.
The raw truth is the initial proposal was a lot leaner than what finally got adopted. We started out with a horse and sort of came out a camel. It's complex, but it basically says that the state initiative process shall not be used to do those things I named in my testimony, create an exclusive economic benefit, et cetera, et cetera, et cetera. But one can always bring an amendment to eliminate a current provision of the Ohio Constitution. You and your group could circulate petitions and qualify a proposed amendment that would wipe out one thing and create something else. And I think that was the thinking that went into creating the language that is now part of the Ohio Constitution. And Laura can clean me up if I fracture this, but in layman's terms, should an organization come forward and attempt to use the state constitutional process to create a monopoly, a duopoly, a special economic benefit not available to similarly situated individuals, then they would have to get voters to pull the lever twice for two things. One is to eliminate the existing prohibition in the state constitution, and the second would be to pass our plan.
Got it.
So you're creating two hurdles for any group. You're asking the voters, do you really want to get rid of this monopoly bar, this
Right.
monopoly hurdle? And if you say, yes, we are, then do you want to prove the plan that these guys are forwarding?
Yeah.
Laura, did I, in layman's terms, do that accurately enough?
Yes.
Thank you.
Thank you.
I am always wary of practicing law without a license.
Are there any comments or questions by commission members?
Can I ask one more, Chair?
Yes, of
Sorry,
course.
I don't mean to. Please jump in. Going back to the signature threshold, to place an initiative petition on the ballot, I just want to underscore, this is more of a statement, but I'm asking for confirmation that I have this correctly. So the Ohio Constitution requires 10% of the electorate for an initiative petition to qualify for the ballot, and the Columbus City Charter, their threshold is 6% of the Columbus City electorate.
It's now 5. It originally was 6. In
Okay.
1933, it was lowered to 5.
And so the current threshold for an initiative petition is 5%.
Correct.
And the state's, just to be clear, is 10.
It is 10 for a proposed constitutional amendment. It's 6% for a proposed initiated law.
Yeah, gotcha. Thank you.
Chair, I do have another question. As it relates to the amendment from 2015, was there a change or alteration in the timeline in which a party would have to collect signatures?
No.
No? Okay. Thank you.
Okay, now exhaust your questions and comments, because he's only going to be here one time.
I would just add a point just for what exists in our charter now. Yeah, for the 5% that is required of the signatures from from the prior municipal election for mayor is the same for the initiated ordinance, which Pro Energy took up and is using that vehicle to attempting to get that on the ballot. To amend the charter, a citizen initiative petition would have to obtain 10% of the previous regular municipal election. So for the route they're taking, it's 5 for us and 10 for the state.
Okay,
Can I ask one more?
of course.
I'm sorry, so please
No, that's what
jump
we're
in
here
if
for, to
others
have the
I don't wanna-
discussion.
I don't want to ask all
Okay.
the questions. Since we have you here, I'll just ask, do you have any recommendations specifically that we should be considering for the Charter Review Commission?
I have had the privilege of having some correspondence and meetings with City Attorney Klein and Laura and Rich in Zach's office. And I thought rather than, again, be accused of practicing law without a license, it'd be best for the city attorney's office to get into the detail of what you should consider. But in my experience and in my research, I would strongly support the recommendations that are going to be coming forward from the city attorney's office.
Okay, thank you.
And we will be hearing those later on in the meeting today. So thank you.
Thank you very much.
Thank you.
Well, next we have Director Joe Lombardi. And Joe, I believe you probably have a slide deck that you would like to present to us. Okay.
Up too much of your time on it. Thank you, Chair Bartley and members of the commission. I'm Joe Lombardi. I'm the Director of Finance Management for the City of Columbus, and put together a quick overview of what the impact would be with the Pro Energy Issue 7 initiative. I want to thank Mr. Curtin for the historical background. I was very intrigued by that. Hopefully I can get a copy of that speech. I'd really like to read that. It was really good. Try not to take up too much of the commission's time because I know you have a lot of work. But first thing we want to look at is just the overview of Issue 7. I've heard a couple different numbers in the last month or so when I've been talking about this. I'm going to use the 87 million, the initial number that I've heard more often than the 42 million. And they seek the 87 million from the Columbus's general fund. Their claim is that it will be used for energy conservation, clean energy, education, and subsidies to customers. The concern we've had then that we have now is where's the oversight and the accountability of that $87 million? We still don't know what entity or what organization will be the fiscal agent of the city taxpayers' dollars. Everything I've read about it, it doesn't appear that anyone can answer that question. The general fund supports many of our basic city services, your police and fire, your refuse collection, the health department, and recreation and parks. Those are your true public services that the government should provide, and that is what the general fund supports with their budget. So what does the $87 million look like? It's equivalent to about 10% of the general fund's operating budget. Nearly the entire balance of the rainy day fund that we currently have, it is projected at the end of this year, that balance will be $89.5 million. The rainy day fund, as folks know, is our reserves. That is for use of what I would call, and I think the auditor would agree, catastrophic situations, economic downturns like we saw in 08 and 09. I look at this as your retirement as opposed to your savings account. This would be dipping into your retirement fund. There are no other reserve funds that can be pulled from. We do have a basic city services fund, but that is very fluid. 1 year it could be at 0, the next year it could be at 20 million. That is not a fund that we typically use as our retirement fund or our reserve fund. If you recall the 08 and 09 Great Recession, it took over a decade to replenish what we had to take out of it then to get us to this 89.5 million. That is 10 years' worth of a budget cycle to even get it to where we are today. And quite frankly, if you look at some of the best practices, they'll tell you that it should be at least 10 to 12%. Your reserve should be 10 to 12% of your operating budget. And even at the 89.5 million, we're not quite at the 10% that most organizations will tell you that's what you need. Those budget numbers, when I look at 87 million, I think of some of our essential service departments' budgets. Our Division of Refuse total budget is 50 million. The Department of Health is 30 million. And Recreation and Parks Department is 45 million. So that 87 million is more than their budgets, and if you would combine refuse and health, you'd have at least 80 million that you would have to cut from those two departments. So I've been asked a lot what the plans would be for the city if this would happen. While I have no specific solution today, and I've worked with the mayor and the chief of staff and others, and council members have asked as well, I do have some ideas that we would have to look at. Number one would be layoffs. Majority of budgets are personnel. If you recall in 08, 09, many of those cuts and layoffs and furloughs were done through our Recreation and Parks Department and our Health Department. But as you know now, with the pandemic that just occurred, those two departments are very, very critical to our children, to our young people, and to the folks that need public health. So those two departments are no longer the two departments that you would look at to make budget cuts. They're too important in today's world to make those massive cuts. So you would have to go through all your general fund budget departments and probably make massive reductions in all the budgets in the general fund, potentially eliminating some of the department's abilities to provide their basic city services to our community. You could use the entire rainy day fund. I know that Deputy Auditor Wilds will be not real happy with that because that would impede our AAA bond rating. And that would affect our capital budgets. And that would affect a fact if we had another economic downturn, we'd have no safety net to be able to get us out of it, and more cuts would have to happen. Using up that entire fund is probably not the right thing to do. We cannot use the enterprise funds. Those are the funds of public utilities or anybody that accepts fees for their budget, do not take income tax. And then, or a combination of all these options. So this would be very devastating to our budget, to the community, more importantly. Any amount of that nature would certainly put a level of service that we provide to our residents day in and day out in jeopardy. And I can't stress enough that there are certain departments that we're not going to be able to cut because of the necessary services that they provide to our residents. And to take the entire retirement fund or the rainy day fund is the worst option because it affects more than just trying to rebuild it. It is going to affect a trickle-down effect on our capital program, our AAA. We would probably be downgraded, and I don't want to speak to that. I'll allow the auditor's office to speak to that, but we would certainly be downgraded because one of the reasons why we maintain that AAA bond rating is because we have that $87 million rainy day fund that we haven't touched that I can recall since 08 and 09. So it would not be good for our community. Chair Bartley, that was as as high-level summary as I could give you that I know today. I don't have a crystal ball to be able to tell you what I would do. I would run for the hills, but I do thank the commission for allowing me an opportunity to speak to the impact of this initiative, and I will entertain any questions that anybody may have at this time.
Thank you, Director Lombardi. Appreciate you taking the time to explain particularly the devastating impact that this type of initiative could have had on the city of Columbus if 7 had passed. So again, I want to open this up to questions from commission members of Director Lombardi.
Madam Chair, I do have a question. This relates to legal action taken, because you laid out, and thank you for your presentation, you laid out the consequences if an issue like this passed. If an issue like this were to pass in the future, what legal action could the city take against the party that imposed that, that issue?
Yeah, I'm going to have to defer to my counsel.
Thank you. That depends. So as was mentioned during Mr. Curtin's remarks, there were some concerns about how this particular group had come to be formed and whether or not they complied with requirements under campaign finance and election laws. So there's a whole area of investigation that might be associated with any individual group, depending upon how they went about getting it on the ballot. But if you're talking simply about the fact that if it had been adopted by voters, and now the question is going forward, what can the city do or not do? Actually, it's an open question. There are provisions of the Ohio Constitution that deal with limitations on what the General Assembly can and cannot do, and when it can and cannot do it, in reference to things that have been voted on by the voters. There's not a similar described process within our city charter. So there would be the possibility that council would be able to look at potentially limiting some of the ordinances that might have been passed at the ballot box, but that carries with it its own political question. If the electors say this is what we want, how do you then go about explaining to the populace that, well, there's some issues here with what we've passed? There are challenges that the city attorney's office may be able to bring under the city attorney's duties under the charter regarding misapplication or misappropriation of funds, but that again is going to depend upon the specific language that might have been adopted. There are steps along the way in terms of moving to implement it. There might be something that would raise the auditor's requirements to say, no, I can't certify that warrant, for instance, because there isn't sufficient funds in the general fund. So it really would be dependent upon the specific ordinance and or charter amendment that was brought. The city wouldn't be lacking in any ability to respond. The question is, at what risk would the city be placed during that period of time where it might be considering its options? Because as Mr. Lombardi mentioned, one of the things that's out there is the city's bond rating. So even if down the line, council or the city attorney or the city auditor might be able to step in with some sort of legal action to protect the city's funds or to seek some sort of remedy from the individuals that had brought this during that period of time, it may well be that we suffer a financial consequence because our bond rating comes to be in question. And so there's a lot of potential attendant and collateral pieces of damage that are difficult to predict from this point, but all of those things together make it imperative for us to consider if there's anything we can do on the front end to prohibit some of those things from getting to that point. That answers your question.
Thank you. Yeah, thank you.
Just a quick question, Chair Bartley. Director, are you familiar with any other initiative petitions that have had this kind of budget, that would impose this kind of budgetary strain on City of Columbus's finances, either passed or proposed? Is there anything that even comes in the neighborhood of putting this kind of financial strain on municipality?
And I'd hate to say this, but I've been with the city for 32 years, and I don't recall anything quite like this. I do recall some recessions that we were able to get out of, and in the 08-09 income tax increase to get through that. but nothing to where someone was taking general fund money and no oversight over that money. I do not recall that.
Just a quick follow-up, Chair. Have there been any initiative petitions that have had any financial strain, that have placed any financial strain or costs on the city? And if so, can you speak to sort of the degree?
Yeah, I can't think of any. City attorney may know.
I would say that this one was fairly unique in terms of it being very specifically. Every time you have an initiative petition or a charter petition, there may be attendant costs in terms of seeking to implement whatever the policy change might be recommended within that. Sometimes it's as simple as an initiated petition discussing a change in, I don't know, a criminal provision. But that might not have an actual cost to the city. But if you're talking about any kind of initiated petition where it is about contracting or granting funds or endowing funds or something along those lines, and there's nothing in our charter specifically prohibiting that from happening, then it would have a financial impact, both in terms of what was actually being asked for, but also as the potential attendant hits to our financial standing.
And one more, just follow up on that. Thank you. But that hasn't happened up until this. We haven't seen that sort of obligation to contract or those other items you just mentioned until this one, right? Am I understanding this?
Until
the
the
history
series
correct?
of them. So there have been a number of attempts with this one group over a period of time to try and do a similar sort of thing.
Got it.
So there wasn't just the one that was presented on, there's one that's pending right now. There was another one that didn't gain enough signatures, so there have been a series.
Got it. Thanks.
Any other questions for Director Lombardi?
Is there a cost that's attended to starting one of these initiatives? So has that group committed funds to doing that?
I'm going to defer, the city clerk's not here today. I think there is a nominal set of filing fees at various points in time, but I'm not aware of it being a significant cost.
It would not be something that would prohibit them from doing this again?
No.
Oh, please.
Part of covering City Hall back in the late 70s, long before Joe got to City Hall. The only one I can remember, and some of you, Nana certainly remembers Jack Gibbs. Jack Gibbs was an educator and an avid sports fan in our town. He led the first effort to get the voters to approve an indoor sports arena. And this was in 1978. And his proposal would have required a bond issue, a city bond issue, to finance the construction of that indoor sports arena. And so it had its own funding source built into the issue, but the question remains, well, what if that did not generate sufficient funds over time to support the capital and operating expenses with that issue? It went down big in June of '78. I don't remember the ratio, but that's the only one I can recall that would have been a big claim on the city's fiscal house, and that was in the late 70s.
Thank you. Any other questions from commission members?
Madam
Yes.
Chair, I do have a question. With respect to issue 7, Pro Energy Ohio, the LLC, the initiative, I'm sorry, was there or would there have been a contractual agreement between the city and that respective party if they were to receive funding with respect to governance or any
No.
kind of contractual agreement?
No, the way that it was written then and the way that it's written in the most recent iteration, they have essentially tried to create a fund that the city auditor would be directing money into a fund and that they would have, by operation of the ordinance itself, the authority to draw down from the fund. But there wasn't a specific authorization to enter into contract, no.
Is that something that we should take into consideration just with any type of transaction between the city and outside parties?
Yeah, yes, I mean, that's something that definitely, when the city itself, if the city itself were to make some sort of an investment that was similar to this, then, and the city were going to provide to an outside source funding in order to accomplish the tasks that the city wanted to accomplish, yes, there would be some sort of an agreement. It would either be a grant agreement or a services contract agreement, what have you, and that would need to be part of the ordinance. That said, it's not uncommon to have an ordinance that creates a fund and to place money into a fund. The issue here, in terms of the structure of the ordinance, is that it allows them to simply access it without that instrument guiding how those funds are to be used. Correct.
Thank you, thank you.
Thank you.
Madam Chair, I have one more question.
That's fine.
As it relates to procurement or service opportunities or grant opportunities, are there any other instances where the city allocates funding to outside parties, donations, whatever it may be? And if so, are there any contracts dealt between those instances?
Yes and yes.
Okay.
So it's one of the functions of city government, of the city council in particular, to determine how best to use general funds to advance the causes that the city wishes to advance. Sometimes that is done by delivering funds through the general budget to the various departments to do work. But other times there are things that the city has determined through its legislative body is an important policy objective that they want to pursue, where there might be a not-for-profit who performs that particular function already, or maybe it's something outside of the expertise of the city. For instance, we want to design a new building and we want to hire an architect to do that. So the procurement process, the grant administrative process is developed within the city to do those things, but it's important to note that it's part of the budgeting process. It's not, determined from an external third-party source. I want X amount dedicated to a specific task or specific policy that the city itself has not considered as part of its larger budget, so that Mr. Lombardi can budget for it, and so that Ms. Wild can make sure that we have the money in the funds in order to deliver to it.
Okay. Thank you.
Any other comments, questions by commission members?
I do have one more question.
That's fine.
This speaks to, and Laura, I think you may have answered it already, but the enforcement of payment. So if someone were to receive, a grant to receive funding, whether through a ballot initiative or whatever it may be, who is the enforcing party that would force the departmental agency or just the city of Columbus to allocate that funding out to that party? So if the government agency, the department just said, no, we're not paying, we're not going to do it, who would then say, no, you have to allocate that funding?
So it's a complicated question.
Okay.
So if the legislative body had properly enacted a piece of legislation indicating that money is going to be spent in the following way, and you had a public official say, I'm not going to do it, then there are mechanisms available at the state level to seek a writ to order that particular public official to go forward and do the act that they have been told to do. The initiative petition would act as a legislative act. So just because it's coming from the people rather than coming from city council, it's still a legislative act. And if it is enacted by the vote, then the city officials would be obliged to follow whatever the ordinance tells them to do. This then places the city official in a potentially precarious position because they may have a legitimate act or ordinance informing them they have to do X, but they might have a duty or obligation under either the city charter or state law to not do X. For instance, the auditor is unable, pursuant to her statutory duties, to release funds if there's not sufficient funds in the general fund to support doing that. There are certain obligations on fiscal officers who have to place a bond as they assume those positions to assure that they are also keeping and preserving the city funds. And so if there's not enough money budgeted for it, Mr. Lombardi can't send, there's nothing to send out. There are obligations within the city charter upon the office of the city attorney to assure that public funds are properly spent. And if the city attorney is aware of the fact that they are not, then there are obligations on behalf of the city attorney to seek those orders of writ, which would place our office in an interesting position as well, because there's also a provision of the charter that requires us to also seek the writ to force somebody to do what the ordinance tells them to do. So it would be an interesting series of events that would probably evolve out of this, but everybody would be trying to resolve the tension between a legitimate order and their statutory duties. And in some cases, they might defend against the legitimate order by saying, yes, there's an order out here, but I'm going to contest whether or not it is in fact legitimate because my duties say I can't do it. So again, it's really going to depend upon the specific language that might be brought forth.
Gotcha, okay, thank you. I have one more question, Madam Chair. Sorry, I always have questions. Sorry. And so what I'm leading to is, if there is a legal case made by the city to say that we are not going to pay an entity like that was mentioned earlier, the funding that the citizens had voted on to allocate because of the consequences associated with that initiative passing, could then the argument be made at the courts that, similar to the legislation or the amendment that was drafted in 2015, could that argument be used in the court of law as it relates to public entities receiving, or private entities receiving public funds without any governance whatsoever? And that should not happen. Is there any legal basis for?
Potentially, and it really would depend upon what ordinance actually gets passed.
Okay.
Because there are things that might be detrimental to the city's finances in terms of the rainy day fund and general operating budget, right? That are in and of themselves not an improper act. And then there are things that are an improper act. And so it would really depend on what the ordinance language was, what it's requiring any particular public official to do or not do, what the existing circumstances are at the city and the capability of being able to do or not do it, and then the relative obligations and duties of the various individuals that would be implicated by the ordinance and how they would then have to respond. So you might have a very interesting legal battle, which in and of itself carries a cost. And the reason that I say that is while the city attorney, I'm joking about it being paid, while the city attorney's office has a statutory obligation to defend, it would have a conflicting obligation to defend individual officials, the actual funds for the city, and then the potential for the individual who got it passed in the first place to insist upon the city filing an action against the individual public officials to do their duty. So you would have a very interesting set of conflicting legal duties and obligations were something like that to go forward that raises those questions of the ability to pay and the authority to deliver it to a third-party entity.
Thank you. That's it, I promise, for now.
Okay. If there are no more questions of, who was speaking? It was Director Lombardi. We will go next to Deputy Auditor Darlene Wiles
Thank you, Chair
for
Bartley.
City Revenue.
Yes, thank you, Chair Bartley. My name is Darlene Wiles. I'm the Deputy City Auditor. Auditor Kilgore sends her apologies for not being here today. In November 2021, Auditor Kilgore was up for re-election and she was running unopposed. So instead of campaigning for herself, she was campaigning against Issue 7. I thought a way of communicating her thoughts and her opposition to Issue 7 would be to read a letter that she wrote to the citizens of Columbus. It's very concise, very short, right to the point, and I think it covers all of the issues. Dear fellow, and the letter is dated October 18th, 2021. Dear fellow citizen, As Columbus City Auditor, I am entrusted to be the fiduciary for the city. This means I have an obligation to protect public funds and speak up when the integrity of those funds or the transparent financial processes are in jeopardy. I take this role very seriously. In my 4 years as your city auditor, I have worked tirelessly to preserve our AAA bond rating and have maintained the city's award-winning commitment to financial transparency. Never have I needed to sound an alarm due to an impending threat from an outside organization, but today I write for that reason. Issue 7 is an initiative that Columbus voters will find on the November ballot. Issue 7's language contains phrases like clean energy and energy efficiency. But it is critical that the residents understand that this is not a city-sanctioned program. This initiative was put on the ballot by a for-profit company. Issue 7 would require the city to move $87 million out of the general fund and transfer a large portion to this company's control. All of the processes that make our city's financial management strong, our systems of checks and balances, public budgeting, financial reporting, and our ability to independently audit would be bypassed. Contextually, $87 million is approximately 10% of our general fund. If Issue 7 passes, city leaders will be forced to make difficult and significant cuts to basic services, including programs like public health, public safety, and parks. This is not a mere warning, given that the city is already grappling with COVID-19 economic recovery and the effects of remote work on our income tax collections. Issue 7 would unquestionably impact safety and services to citizens. I cannot be more sincere with my plea that you learn more about Issue 7 and its implications. I think that really summarizes, I think, a lot of things Joe said were repeated in her letter. And we were very happy when this issue was voted down.
Are there any questions of the Deputy Auditor? Okay. Well, let's go to the proposal that's coming before us for self-dealing regarding resident tax revenue. And we'll have a presentation by Laura Baker-Morish of the City Attorney's Office.
Thank you, Chair. So I want to begin my remarks by saying that the City Attorney's Office is bringing forth to the Commission some recommended charter language to deal with the issues that you have been hearing about today and to answer some of the questions that have been asked of us and the issues and concerns that have been raised. But I wanted to preface my presentation by saying that while we feel that these recommendations will go a long way to strengthening the city's position, none of these is going to definitively put an end to this entirely for reasons that we're going to discuss. Okay? So we already talked a little bit here early today throughout the course of these questions about the nature of the concern. The power of the municipal initiative petition could be used to allow a private individual or business to obtain access to public funds without being potentially accountable to the citizens of the city of Columbus. Where the petitioners seek to enact an initiated ordinance, the number of signatures needed to get on the ballot is fairly small, 5% of total votes cast in the last mayoral election, and it's susceptible to not being reflective of the community as a whole. You could have individuals gaining signatures at 5% of the number of people who voted in the last mayoral election, and it could be all from one area of the city of Columbus. So think about the fact that it's not just about maybe one potential issue, but could also just be about a single issue interest group of any kind that would be able to obtain those level of signatures. Where petitioners seek to enact an initiated charter amendment, the number is indeed a little bit higher, but it's still relatively small, 10% of total votes cast. And most importantly, in order to overcome or to change or amend what those individuals might be able to enact as a charter amendment, you'd have to go back to the ballot and seek it to be changed that way. So it's a little bit more permanent in the event that they're able to obtain the 10% necessary. So that's the general nature of the concern that we've been talking about this afternoon. As Mr. Curtin mentioned, Columbus is unique. It's not unique. The state has dealt with similar issues with the casino, and they dealt with the issues with marijuana monopoly in 2015. And the interesting part about that, as you recall, is that even in trying to address those concerns that were raised at the statewide level, there was a recognition, and as Mr. Curtin talked about our history, that we were trying to address the concerns that have been raised while at the same time trying to preserve for the citizens of the state of Ohio, the authority to have an initiated petition. And so we already have contained within the Ohio Constitution this, approval for this process. So how can we balance those two needs? So as Mr. Curtin mentioned, there are provisions within the Ohio Constitution. I'm going to talk a little bit about a second provision that's kind of related to the one that he discussed from 2015. There was a provision enacted in 1912 during that constitutional convention. It's existing right now in Article 8, Section 6. This specific provision states, "No laws shall be passed authorizing any city," and I'm just going to jump to the stuff that's relevant to us, by the way, "shall be authorizing any city by vote of its citizens or otherwise, and then to become a stockholder in any joint stock company, corporation, or association whatever, or to raise money for, or to loan its credit to, or in aid of any such company, corporation, or association." So this is an existing provision of the Ohio Constitution that is not used terribly often, but that specifically speaks to the ability to prohibit individuals from using the power to enact legislation. And notice, it's not limited here to initiative petitions. "No law shall be passed authorizing any city by vote of its citizen or otherwise to enter into these kinds of arrangements with private for-profit corporations and companies." This is specifically talking about the concept or the idea of the city and a private entity essentially acting as one. This is distinct from economic development that you might see and hear about in the sense that there are other provisions of the Ohio Constitution and the Ohio Revised Code that specifically allow for some level of private and public partnerships in order to advance economic development for the furtherance of the social welfare of the city itself. But what this does prohibit is essentially governmental entities becoming for-profit ventures themselves. And one of the things that's of concern when we're talking about this provision of the Ohio Constitution is the ability of an outside private company to use the funds and the assets of a city as essentially its own line and loan, its own credit, okay? So in the case where we're talking about the clean energy provisions, and they're talking about the city auditor setting up a separate fund, and that fund will be dedicated solely for their use. Not only would that allow that particular private for-profit company to access those funds for the purposes that they determine they're going to use them for, but it also would allow them to go out and seek additional funds from banks, from other kinds of providers and lenders, because they would be able to demonstrate that they had this money available to them. It's essentially the city loaning them its credit. So that was the first provision. The second one is the one that Mike spoke about, the Ohio Constitution, Article 2, Section 1E, that was adopted in 2015. This is the actual language from that provision of the Ohio Constitution. And again, I'm just going to talk about the parts that are specifically relevant to the situation we're discussing here today. Restraint of trade or commerce being injurious to the state and its citizens, the power of the initiative shall not be used to pass an amendment to this Constitution that would grant or create a monopoly, oligopoly, or cartel, specify or determine a tax rate, or confer a commercial interest, commercial right, or commercial license to any person, non-public entity, or group of persons or non-public entities, however organized, however they are construed. That's the basic provision. This, again, was specifically brought about to address the situation involving the marijuana marijuana constitutional amendment initiative, and it goes through in its second part and lays out the process which shall be taken in the event that somebody attempts to do so, notwithstanding this provision of the Ohio Constitution. So, if a constitutional amendment proposed by initiative petition is certified to appear on the ballot, and in the opinion of the Ohio Ballot Board, the amendment would conflict with the provision that I just read, Then the board shall prescribe 2 separate questions to appear on the ballot as follows. The first question shall be, shall the petitioner, in violation of Division B1 of Section 1E of Article 2, that's what I just read, of the Ohio Constitution, be authorized to initiate a constitutional amendment that grants or creates a monopoly, oligopoly, or cartel, et cetera, et cetera? In other words, the first question that the voters have to answer is, recognize that there is a provision of the Ohio Constitution that prohibits this. Shall we allow this petition to go forward? They have to answer that first. The second question shall describe the actual proposed constitutional amendment itself. So instead of just the amendment appearing on its own, it appears first with the question that calls attention to the voter of the fact that this thing that is being proposed would be in direct contradiction with something that exists currently in the Ohio Constitution. You get to see if both questions are approved or affirmed by a majority of the electors voting on them, then the constitutional amendment shall take effect. If only one question is approved or affirmed by a majority of the electors voting on it, then the constitutional amendment shall not take effect. So in other words, you have to get affirmative votes on both in order to amend the Constitution, or at least to allow, to amend the Constitution with the new constitutional language. So those are the things that the state has done. They have not eliminated the power of the initiative, but they have taken a look at the concerns that we have looked at here today, and they have created processes and procedures by which individuals who still seek to have pieces of legislation, constitutional amendments with those provisions, and they've made them go through a particular process in order to get there. The idea being you want to make sure that the people who are voting on it have a clear understanding of what it is that they're voting on, and we want to make sure that we are protecting the funds, the public funds. So what are we recommending then? So before we get to it, there it is. But before we get to it, we have to talk about home rule. Remember home rule? Remember home rule from a few weeks ago. So the Ohio Constitution is this awesome thing, and as Mr. Curtin stated, when these constitutional amendments came about to deal with self-dealing and to deal with public corruption, it also created the Home Rule Amendment. So you have Ohio constitutional provisions that allow for an initiative petition. At the same time, you have Ohio constitutional provisions that allow for home rule and local self-governance. And what you have then is this tension between the two. If you have preserved for the people the right of the initiative petition, the question is how far can home rule go to prohibit those individuals from having access to do that which the Ohio Constitution allows them to do specifically. So that's the challenge in us trying to figure out how do we take our charter and provide protections for the city without running afoul of that tension that exists at the Ohio Constitution. Because remember, above all, even city charter, great powers of local self-governance, but it comes from the Ohio Constitution. And the powers of the individuals of the initiative come from the Ohio Constitution as well. So that's why in the city attorney's office, when this question was brought to us, and that's why I go back to my initial comment, I can't guarantee, this hasn't been tested, that this will fix it for good. But what I can say is that we are going to honor that tension, and we're going to honor the fact that there is a right to the initiative, but we're also going to take what the General Assembly has done at the Ohio Constitutional Amendment level, and we're going to attempt to mirror that for our city to provide ourselves similar protections. So when we take a look at amending the charter mirroring the Ohio Constitution, we are proposing, and I need a title, by the way, Section 42-16. I haven't titled it, so I need a title. But in any event, this provision would largely mirror the substantive aspects of the two constitutional provisions that I just described for you. So Section A mirrors the 2015 amendment to deal with monopolies, and Section B mirrors the 1912 amendment that deals with entering into arrangements with private for-profit corporations. That language is almost identical. About the only thing that is different is I've added the city of Columbus instead of the state in the places where those references were made. The other thing that that we have done is to recommend that we make a specific reference back so that it's clear to anybody looking at our city charter that we, in enacting these provisions, are deriving that authority directly from the Ohio Constitution, and that we are attempting to use the power of the Ohio Constitution to protect Columbus. This argument's particularly strong in terms of the constitutional authority in paragraph B, because if you remember, the Ohio constitutional provision itself said, no laws shall be passed in a city, whether it be by vote of the electors or otherwise. It's already there. The other provision is strong in the sense that it's specifically dealing with the kind of behavior that we've been seeing with the initiative petitions that are coming forward. So they each have their strengths. The weaknesses of A are that question of whether or not this is something that we can do via charter when at the constitutional level it only addresses the state. And for B, we clearly have authority to do this. Will it cover everything that we need to cover? So the city attorney's recommendation, being the lawyers that we are, let's do both, right? So the second thing we're recommending to go along with that, and I'm very glad that you had this ahead of time because as you can see, I tried to make this succinct, but it is still entirely too tiny to see on that board. So hopefully you have it in front of you as well, but I can give you the short version of what you're looking at. This also mirrors what you saw in the 2015 Ohio constitutional amendments. So what it does is it says if an individual or if a group puts forward an initiative petition that is determined to be in violation of either paragraph A or B, so in violation of either the monopoly one from 2015 or the 1912 one about private companies, then when that particular initiative petition appears on the ballot, it will also have the language saying to the person who's voting, this is determined to be in violation. Do you want to, enact something that is in violation of our city charter? So everything you're seeing on here is basically that done for each one of A and B, and done for both the initiative charter petition and the initiative ordinance petition. So that's why you're seeing it multiple times. Under the Ohio Constitution, they're only dealing with charter amendments. We're addressing charter and initiative ordinance, and we're addressing both the 1912 and the 1915 constitutional provisions. But in all other regards, the process would be the same. Any questions on that before I go on to the next one? Because these are all related together. And you can always come back to the end too, but any questions on what the structure at least would be? Okay.
I do have a question.
Yes.
I'm sorry, Madam Chair.
That's fine.
Would these be two separate issues, or would these issues be combined into one ballot initiative or recommendation to council, city council?
So let me answer it the way that I can best describe it, if that makes sense. So an initiative petition would come forward and they would go through the normal initiative petition process, which means the first step would be that they would file a pre-certification petition. That always currently goes to the city attorney's office for review. We, at that point in time, make a sufficiency determination as to process. That's the existing process. At that point in time, the city attorney's office would then also review to determine whether or not this particular petition that's been brought forth potentially violates either A or B. And we would make a recommendation if that petition signatures came back with a sufficient number of signatures such that it now gets to council to determine to put on the ballot. We would then make the recommendation, depending upon which bucket it falls into, which provision should apply.
Okay.
Right.
Gotcha. Thank you.
Sure. And then if it gets to the ballot, the same process as would exist at the state constitutional level, the voters would be asked both, do you want to approve something that's going to be in violation of city charter? And if yes, do you want to approve this? If both questions are approved or affirmed, that's the next page, sorry, are approved or affirmed by a majority of the electors voting on them, then the ordinance or charter shall take effect. If only one question is approved or affirmed by a majority, then the ordinance or charter amendment shall not take effect. So again, that language directly mirrors what's happening at the state constitutional level. Yes.
Madam Chair, just a quick question. Are there other provisions in the Ohio Constitution related to citizen initiatives that we're not mirroring?
There are other provisions of the Ohio Constitution relating to citizen initiatives. I am not aware of any one that we don't address in some way, shape, or form in our charter, potentially with slightly different language. But in terms of the concern that we're addressing regarding self-dealing, I'm not aware of any other ones that
Got it.
address that issue.
So in other words, if I may, we may mirror on the self-dealing provisions that are in the Ohio Constitution, but we may not mirror the signature threshold question to make it the same as the state.
Correct. I mean, we may or may not, we can make that choice.
Right.
And we do have a recommendation coming up regarding the signature component. But definitely, it's one of those things where as a city charter, if we choose to go, we could choose all of these, some of these, none of these. And it also doesn't mean that we have to change the rest of our existing process. These would be in addition to, in other words, they'd be slotted into existing process.
Got it. Okay, thanks.
So the second recommendation that we have is to provide greater transparency. So a number of the individuals that testified here today talked about not just the potential hit to the city coffers if something like this would go forward, but they talked about the need to go out into the community and make the case to the community and to educate voters about what the impact might be. That's an important thing, and that should continue to happen regardless of what we recommend here today. But the reason that individuals had to go and do that is because it's not necessarily apparent from the initiative petitions that come before the voters what that impact might actually be. And so the danger that you have is that people who go in to their ballot and to vote, who maybe have not been exposed to an education piece or who are simply unaware of what is being brought forth before them, don't have the ability to know when they go in and cast that ballot what the potential impact might be. So the second thing that we are recommending is for petitions that would violate or potentially violate the other provisions of self-dealing. So this would not be for every single initiative petition. These would be for the ones that we already believe are of concern. These are for the ones that are already, there's a concern about whether or not there's a monopoly or there's working with a private company. We would then recommend that we have disclosure requirements that are also required in addition to the existing disclosure requirements that already exist in the city charter for just individuals generally who initiate petitions. So right now, there's some general disclosure requirements about, who are the names of the petitioners and what are their addresses and are they electors, and things along those lines. But we would recommend going beyond that and adding additional disclosure obligations that will specifically address the concerns related to the monetary aspect. So this would be, all right, we already talked about, the page before was making it clear that this would just apply to individuals who are putting forth a petition that potentially violates A or B. And now we're to transparency, what it would require of them, the name and address of each member of the petition committee. That's no different than for every petition committee. The name and address of each person, non-public entity, or group of persons or non-public entities, or any combination thereof, who will receive or are intended to receive a commercial interest, a commercial right, a commercial license, or a private commercial benefit of any kind under the initiated ordinance or charter amendment. So if we have a petition or that is allowing for these kinds of creations of commercial rights or commercial benefits, we want then those individuals to disclose, okay, who's getting that money? To the point, how is that money going to be used? Who is going to be the one that's going to be benefiting from this? The amount of public money that each person, non-public entity, or group of persons and non-public entities or combination thereof will obtain or is expected either to obtain or to have access to from the city in each of the first three fiscal years following the effective date of the initiated ordinance or charter amendment. So again, who's going to get how much? How long will they have it? What kind? Who's going to be able to have access to it in terms of being able to loan the city's credit, as we discussed earlier? Then, the failure to disclose any of the information required in this section will result in the invalidity of all signatures contained on such part petition. and strict compliance with this section is required pursuant to obligations under Title 35 of the revised code. Title 35 is the elections code under the Ohio Revised Code. And so now we're getting back to that initial conversation that I talked about, home rule, right? So when you look at the Supreme Court decisions from the Ohio Supreme Court dealing with charter amendments and dealing with the initiative petition and the authority and the ability of the city to limit individuals getting access to the ballot, what you find out there generally, and I think John alluded to this last week, what you find out there generally is that most of those decisions coming from the Ohio Supreme Court are going to err on the side of the petitioner when they was talking about substantive access to the ballot. So to the extent that the city is trying to limit what how a person's access to the ballot, they are probably going to come down on the side of the voter and then on the side of the petitioner and against home rule. But to the extent that the city is looking to assure that there are procedural steps that are being followed, that it has to be filed within a certain period of time, that there has to be a certain number of signatures, that those signatures have to contain certain information, that the certain forms have to be used. To the extent that we're talking about the process, that is still an exercise of home rule and local self-governance. And so these aspects of transparency that we want to assure in order to make, we want to use to assure the protections of the city funds so that the voters know what they're voting for, we're placing additional procedural requirements upon those individuals. And we believe that that would be supported by the home rule jurisprudence. All right. So that is the second big bucket of things. So first is what we're calling informally the two-step, that you first have to, that if you identify a particular initiative petition as violating either the monopoly section and or the 1912 private corporation section, then you have to go through and have the second question on the ballot. So we've been calling that the two-step, two questions. Second thing, transparency, that if you have an initiated petition or a charter amendment petition that addresses one of those two kinds of concerns, that you also then have to provide additional financial information relevant to and specific to the substance of that initiated petition. The third thing we're suggesting, assuring that it is reflective of the community. So at the state level, if you are proposing a charter amendment to the Ohio Constitution, you could not go and get all of your 10% from the last gubernatorial election by just going to Franklin County. So if you got every citizen in Franklin County to vote for it, you know, it's an initiative to support the Columbus Blue Jackets, and you went just to Franklin County and got 10%, and now I'm going to get on the Ohio Constitution I'm going to get on the ballot for an Ohio constitutional amendment to support the Columbus Blue Jackets in some way. Or if you lived in Cleveland and you wanted to support the Cleveland Browns, which is my team, sadly, we won't go there. Yeah. But you see the point. You would have a constitutional amendment that would impact the entire state of Ohio, but it would be able to be controlled by the larger populous centers in Hamilton, Franklin, and Cuyahoga County if that 10% only had to be collected from one specific, or could be collected, from any area of the state. So at the state level, there is a requirement that you have signatures from 44 of the 88 counties, and that those signatures from 44 of the 88 counties constitute 5% of that 10%. I'm going to tell you now, I am not a math whiz, so I have begged Mr. Oswald to please make sure that my math is correct on these things, but it is our desire to mirror what they have done at the state level in our charter by looking at the new districts that we've just adopted starting in 2023 for city council. So the idea behind the next set of slides, and this would be for every kind of petition. This would not just be unique to the ones that are dealing with self-dealing. This is across the board. If we're going to change our charter, if we're going to initiate an ordinance, we want to make sure that it is reflective of the desire not just of one small group within the city, but that it's reflective of the desire of the city across the board. And so the idea would be that in order to obtain the necessary signatures, you would have to get 5 of the 9 council districts and then half of the percentage that would be required. So in the case of initiating an ordinance petition, the overall requirement is 5%, so the obligation would be 2.5%. For a charter amendment, it's 10%, so the obligation would be 5%. and on down the line. So each one of these that you'll see in this packet is just applying the exact same formula depending upon the kind of thing. So it's charter amendment, ordinance amendment, referendum, and recall, and applying those same thoughts of 5 of 9 districts and then half of whatever the overall percentage would be. And I really do hope somebody checks my math on that. So those are the 3 buckets that the city attorney's office is recommending. Again, they are not tested, but we do believe that we have a good faith basis for why we're bringing forth the argument based upon their existence in the Ohio Constitution, based upon the existing election laws, and based upon how Ohio goes about amending its constitution. And with that, I'm here to take any questions.
Are there any
Question,
questions?
Madam Chair. Are you familiar, have any other cities taken a similar approach across Ohio to mirror the language that was passed in, I guess, the early 1900s and more recently?
If they have, I'm not aware of it.
Okay. And a quick follow-up.
Yes, please.
I think you spoke to this earlier, but I'm going to ask again just because I want to get my head around it. The sort of the I'm sorry, I'm trying to phrase this correctly. I mean, it seems to me that if we're not going above and beyond what the limits to the ballot are through the Ohio Constitution, and if we're mirroring what the state has done, and we're asking the residents of the city of Columbus to affirmatively approve this change to the charter, I mean, to me, just on the surface, not being an attorney, that seems very strong from a legal position, from what we're trying to do here. Do you agree with that? What's your sense on the sort of the legal question behind this?
I wish I could read the tea leaves and tell you definitively, but what I can say is that we definitely considered that in making this argument.
Yeah.
You know, but the fact that it has already happened at the Ohio constitutional level gives us an argument both as to the validity of the act, but also as to the authority for the act. And as I said, it has not yet been tested. I don't know what the Ohio Supreme Court ultimately will say, but I can say, based upon the cases that we've seen at the Ohio Supreme Court and the concerns that they have expressed along the way regarding what cities can and cannot do, I think that we are recommending a path that is supported, but unless and until it gets before them, I can't definitively say.
Sure. Thanks.
Other questions or comments by commission members?
Madam Chair, I do have one question. As it relates to the petition committee and the transparency, the language that would be on the petition, there would be detailed information as it relates to not consequences, but the end result of this initiative passing listed on the petition. And that would be up to the petition committee to determine whether, based off of what's listed here, whether or not that language would be on a petition. So if the entity is receiving funding or whatever it may be, I don't want to read the language, but the committee seeks to use municipal powder, so on and so forth. If they are not doing that, then language would not be on the petition. Is that correct, or how would that work? And does that?
Right. It wouldn't get to that point unless they had already brought forth a petition that had requested action that would violate potentially A or B.
Okay.
Right. So we would have to work out the mechanics of how, so right now, we get the entire pre-certification petition all at once, which would contain their proposed language as well as a standard form. And so, and again, in the event that this commission is interested in pursuing this, we would then have to figure out if there would need to be a potential interim step that once there's a determination made that thing you've brought forth potentially violates A or B, now you have to use this form instead of this form, you know what I'm saying? Which would
Yes.
contain that information. But the nice thing is that our existing charter process already has that review at the front end. And so it would be something that we would be able to do during the initial stages, rather than, a year has gone by and now we're saying you didn't have it on there. I mean, we would make sure either through a subsequent tweak to this language or to a policy, and I need to talk to John about how best to do that. But before we went down that road, we wanted to make sure that there was even an interest within this committee of doing this kind of thing, and then we could think about how practically to make sure that that lined up.
Okay. Yeah, the reason why I was asking,
Yeah.
Madam Chair, just wanted to make sure that we eliminated any instances of perceived discriminatory practices. So, we wouldn't have to, if a party said, well, that's not it, well, that has to go to whether some legal hearing or whatever it may be, but to ensure that, again, that the petition committee wouldn't experience or encounter some party saying that, well, that's not right, and try to fight it in some type of way, shape, or form.
And that's always possible, to be
Okay.
honest. I mean,
Either
and that
way.
happens now.
Okay.
Some of the litigation that we've had over time with a variety of petition committees over time have been a dispute between they believing that that petition committee believing that their petition was sufficient and the city attorney's office believing it wasn't, or the Board of Elections believing that it wasn't sufficient, or that their signatures were or not. So the nice thing is that there is already an existing process in place for litigating these things, and it's all on an expedited timetable because they're election-based. So they would have the ability to have and to exercise and to seek judicial remedy. Obviously, it's going to depend upon what the issue is, how they choose to do that.
Gotcha. Okay. Thank you.
Piggybacking off that question a little bit from Des. So for any measure that was brought forth by a citizen initiative petition process that didn't conflict with these new requirements that we would be mirroring in the Ohio Constitution. Let's say a community group brings forth a measure that has really nothing to do with the financial interest. It's, akin to something maybe we've seen before regarding
that wanted
governance.
electric scooters.
Yeah,
Yeah.
or just, the governance structure of the city, award system, et cetera. Nothing would really change for those community groups bringing this forward.
The only one is the percentage across the districts.
Yes, okay, sorry, yes. They would have to get a percentage of the signatures from different parts of the cities
Correct.
based on the district system set up. But generally speaking, setting that aside, there's no additional,
Correct.
okay, thanks.
Any other comments or questions from commission members?
Just one more, Madam Chair, sorry. Just going back to the signature number. So are you not recommending that at this point to change the number of signatures required in total? Or is that a question for later on in this process?
I think that's, I'm sorry, I didn't mean to. We're not specifically recommending it to deal with this particular issue, only because if you change the signature requirement, it would apply to
Right.
everything. And while there's certainly an argument anyway for spreading out among the districts, because we just got districts, I don't know that we, at the city attorney's office, have heard similar issues or concerns about individuals' access to the ballot outside of that. And so that's the reason, that would be a policy call. It's something that the commission could consider, and it's something the commission could do, but that's why we didn't specifically recommend it, because we're only looking at the legal,
Got it.
issues.
Thanks.
Questions? Comments, commission members? Okay, well, we have a lot to take back with us and to review, as we did with the auditor's recommendations prior to. In our next meeting, our process will be to really go into more depth into what we have reviewed, to bring back questions that we may have, and we may ask some of our guests to come back to be able to answer some of those questions as we move forward to what the potential recommendations will be for this particular issue, being self-dealing and resident tax revenue. So if there are no other questions or comments by commission members, I'd like to go to the next agenda item. And I'd also like to give our guests the opportunity to leave if they'd not like to be part of the conversation as far as scheduling of our next meetings. So if you would like to leave, please do. Again, thank you for your time and the information that was covered today. And I'm sure we'll be seeing you back again. And again, thank you.
Thank you.
See you. See you, Joe. Thank you. Okay, so our final item before adjournment today is, again, our schedule. And John, if you'd like to review what we have to date and how we'd like to move forward.
Certainly. So we had agreement on most, coming close to all of the dates that we had submitted for the remainder of the meeting, so we can schedule out basically till the end. And so the dates as for our regular commission meetings, as agreed to so far, are basically every 2 weeks until June, and then we're taking a kind of skipping a week and going a bit. Though we will leave some flexibility in there should we have to deal with additional issues. If there's some things that still need to be addressed, we always have the ability to schedule another. So what we have so far, and you will all be receiving calendar invites for this either tonight or tomorrow. This is the next one being. I should preface this with these are all Wednesdays at 3 p.m. So
3 p.m.
yes, and the dates for the record are April 6th, April 20th, May 4th, May the 18th, June 1st, and June 22nd. And then we have a meeting that would be the final one to probably review the draft report and do an approval of the final recommendations the week of July 4th. But we will get that one scheduled as well. The other item I wanted to bring up is that if Stephanie Shoemaker has not emailed you all already, she will be shortly on looking at your availability for May, probably middle of May, for a public hearing, to which we could hear some comments from the public on items discussed already, and other potential items that we're going to go over at there. It's a little over the halfway mark, so folks would have a pretty good idea what we're up to at this point. So, giving opportunity for speakers to come and just comment on any particular issues that we've gone over, or any that they're particularly concerned with. So the idea I discussed in the first couple of meetings was to have at least 2 public hearings, so that we give the public a chance to comment. I would expect to do the second following the submission of the final report, so probably July. Again, these would be hearings sponsored, by the commission. We would hope that all the folks could make it, but would understand it's if not, like the second public hearing that would be in July would be largely for the benefit of council to hear the public comment on largely should council take up the report? Should they take up the recommendations? Which ones should they, if any? So. But the theme of the first one would be commentary on work completed thus far and what could be to come. So those are the dates as of now, and we'll follow up shortly to confirm those couple others.
Thank you, John. In the packet of information that was within that portal, you should have received a draft timeline that John has just summarized. So if we could just review that for next time and then just confirm those dates and times as we move forward so we can get to our ultimate date as far as giving our recommendations to City Council. by July 8th. Any comments or discussion from council members on that particular issue or agenda item? Okay, hearing none, then I would like to have a motion to adjourn.
So move.
Second,
Second?
all in favor?
Aye.
Okay, we are adjourned, and thank you.
Thanks for putting that together.